Debenture is an instrument evidencing debt. It may constitute a charge on the assets of the company. It is issued after approval by a special resolution from members. It will have option of convertibility on redemption wholly or partly. A debenture shall not carry any voting rights. Secured debentures are issued subject to terms and conditions. A company shall create a debenture redemption reserve to be used only for redemption of debentures, and it is created out of profits available for payment of dividend. The duration of a debenture is not to exceed 10 years, but in case of infrastructure companies, it can be up to 30 years. They are secured by a charge on the properties of the company or its subsidiary or holding or associate companies for due repayment of the debenture amount and the interest thereon. Company to appoint debenture trustee before the issue of the letter of offer and execute a debenture trust deed within 60 days of allotment, and the debenture trustee is required to protect the interests of debenture holders and redress their grievances. Section 44 of the Companies Act says shares or debentures or other interest of any member in a company shall be movable property transferable in the manner provided by the articles of the company. Debenture trust deed is a deed between the company and the trustees. Company mortgages to the trustees all the existing fixed plant and machinery and fixture as a security for due payment of principal with interest and other charges. Monies due to the debenture holders shall become immediately payable in the following eventualities: when the company makes a default, or the company ceases to carry on its business, or an order has been made by the court for winding up of the company, or it is certified by an auditor that the company's liabilities exceed its assets, or in the opinion of trustees, the security of debenture holders is in jeopardy. The trustee shall enter upon and take possession of the mortgaged premises as soon as the security is enforceable. He shall forthwith take steps for the purpose of determining whether the business may be allowed to be carried on or the mortgaged premises shall be realized by sale or otherwise. A trust deed shall be open for inspection to any member or debenture holder of the company. A copy of the trust deed shall be forwarded to any member or debenture holder at his request within 7 days. A debenture trustee is required to be appointed before the issue of prospectus or letter of offer. His name appears in the letter of offer and in all subsequent communications. His written consent will be obtained before appointment, and it will be stated to that effect in the letter of offer. The trust deed in favor of debenture trustees will be executed within 3 months of the closure of the issue. The charge or mortgage created in favor of debenture trustee can be on any specific movable or immovable property. A trustee may be removed when consented by minimum of 3/4 in value of debentures. To ensure debenture trustee remains objective and impartial, he shall not be appointed as such if he is beneficially holding shares in the company, or he is a promoter, director or key managerial personnel of the company or its subsidiary or associates, or he is beneficially entitled to monies otherwise than as remuneration payable, or he is indebted to the company or its subsidiaries or associates, or he has furnished any guarantee in respect of the principal debts of the company, or he is a relative of any promoter or any person who is a director or key managerial person of the company. A debenture redemption reserve is created out of profits of the company available for payment of dividend. It shall not be less than 15% of the debentures maturing during the year ending 31st March of the next year. The DRR shall be created in respect of non-convertible portion of the debenture issue. The amount credited to DRR shall not be utilized except for the purpose of redemption of debentures. The debenture redemption reserve will be maintained in deposits with any scheduled bank or in unencumbered securities of the central or state government. Tribunal helps whenever the assets of the company are likely to become insufficient to discharge the principal. The debenture trustee may file a petition before the tribunal, which after a hearing may impose restrictions on incurring of any further liabilities by the company as felt necessary. Where a company fails to redeem or pay interest when due, the tribunal may on application and after hearing direct the company to redeem the debentures with interest forthwith. Section 73 to 76 of the Companies Act, read with Companies Acceptance of Deposit Rules, contains conditions for acceptance of deposits. deposits by companies. Section 2 subsection 31 says deposit includes receipt of money by way of deposit, loan or in any other form by a company, but it doesn't include such categories which are prescribed under Rule 2 subsection 1 clause C of the Companies Acceptance of Deposit Rules 2014. Two types of depositors: member under section 73 subsection 2 and any person who has made a deposit as per section 76. Section 76 talks of eligible company as a public company which has got a net worth of not less than rupees 100 crores or a turnover of not less than rupees 500 crore. Such an eligible company, before making any invitation to the public for acceptance of deposits, obtains the prior consent of the company in general meeting by means of a special resolution, and such a resolution is filed with the registrar before proceeding further. Section 73 subsection 2 provides for accepting deposits from members subject to fulfillment of certain conditions, passing a resolution in general meeting, filing a copy of the circular along with the statement with the registrar within 30 days before the issue, depositing every 30th April 20% of the deposits maturing in the following financial year under the bank account, deposit repayment reserve account in a scheduled bank, the amount not to be used except for repayment of deposit, arranging for providing security for due repayment of amount of deposit and interest thereon. Where a company doesn't secure the deposits shall be termed as unsecured deposits. A public company having specified net worth or turnover under section 76 subsection 1 may accept deposits from persons other than its members, but it should obtain a credit rating from a recognized credit rating agency and inform the public about the rating given to the company at the time of invitation of deposits, and the rating should be obtained for every year during the tenure of deposits. The company accepting secured deposits from public has to create a charge on its assets within 30 days. A public limited company is permitted to accept or renew deposits for 6 months and above up to 36 months, and the company referred in 73 subsection 2 allowed to accept from members not to exceed 10% of its paid up share capital and free reserves and security premium account. Companies referred to in 76 subsection 1 to accept deposits from public not to exceed 25% of the aggregate of the paid up share capital, free reserves and securities premium account. A company accepting deposits shall dispatch a circular to its members or publish it as an advertisement, and such circular shall be signed by majority of directors, filed with ROC at least 30 days before its issue, and such circular or advertisement remains valid for 6 months from closure of the financial year. The company will appoint a trustee for depositors for creating security for its deposit and a deposit trust deed executed at least 7 days before issue of circular. Security will be created in favor of a trustee by the company on movable or immovable property for due repayment of the amount of deposit and interest thereon. The company shall maintain a register of deposit entering particulars of each depositor within 7 days of issue. It shall file a return of deposits with the registrar on or before 30th day of June every year and furnish information as on 31st day of March duly audited. It shall furnish deposit receipts to the depositors for the amount received within a period of 21 days from the date of receipt of money or from the date of renewal. Company shall maintain liquid assets under deposit repayment reserve account on or before 30th April of each year with any scheduled bank, and it shall be utilized for repayment of deposit. Any contravention of section 73 or 76 will render the company liable for action under section 447. Section 2 subsection 30 defines debentures as including debenture stock, bonds or any other instrument. It evidences a debt. It may or may not constitute a charge on the assets of the company. Section 44 states shares or debentures shall be movable property and they are transferable as per provisions of articles of the company. No company can issue a debenture with any voting right. The date of redemption not to exceed 10 years, and a company may issue convertible debentures also, which can be converted either wholly or partly, but such issue has to be approved by a special resolution of members. Debenture trust deed is made between issuing company and the trustees in form SH12. A trust deed will be opened for inspection to any member or debenture holder as if it is a document similar to register of members of the company. A company to appoint debenture trustee before issuing the prospectus or letter of offer, and a formal debenture trust deed has to be executed within 60 days after the allotment of debentures. A person shall not be appointed as a debenture trustee if he is interested in the company, or if he is a promoter, director, key managerial personnel or an employee in the company, its holding company, its subsidiary or associate company. Before the appointment, a written consent shall be obtained from him, and the letter of offer of debentures shall contain a statement to that effect. The trust deed cannot contain any provision exempting a trustee from any liability for breach of trust, as such exemption shall be void unless it is agreed upon by a majority of 75% of the debenture holders in value. A trustee may be removed only if approved by the holders of, once again, 75% in value of the outstanding debentures, and it should be done in a formal meeting of debenture holders. Debenture trustee has got two main duties. One, to ensure that the assets of the company and of the guarantors, if any, they are sufficient to discharge the interest and principal amount at all times, and that such assets are free from any other encumbrances. A public company having a net worth of 100 crore or a turnover of not less than 500 crore is eligible for making an invitation to the public for acceptance of deposits. The company has to obtain a rating which confirms adequate safety. It has to be obtained from a credit rating agency, and it has to be informed to the public at the time of invitation of deposits from them. Company to execute a deposit trust deed at least 7 days before issuing the advertisement inviting the deposits, it should be in Form DPT2. Every company which accepts deposits from the public which are secured, within 30 days of such acceptance has to create a charge on its assets covering the entire amount not less than the amount of deposits. A company can accept deposits for a term which is not less than 6 months up to and not exceeding 36 months from the date of acceptance or renewal. Company can accept deposits from its members under section 73 subsection 2, and it shall not exceed 10% of the aggregate of paid up capital plus free reserves plus securities premium account of the company. The deposits from public under section 76 subsection 1 not exceeding 25% of share capital, free reserves plus securities premium account. The company on acceptance or renewal of deposit has to issue a deposit receipt to the depositor or his agent within a period of 21 days for the amount received. Whenever there is a withdrawal which is premature withdrawal at the request of the depositor after the expiry of 6 months from the date of such receipt but before the expiry of its regular period, company to reduce the rate of interest by 1% from the fixed rate. Whatever rating the company obtains, it has to obtain every year during the currency of the deposit.